correctly, what you're asking me to request in the second venture would be that accounting,
Right.
right?
Exactly. And we're going
But
to come
how
full
would they
circle around
have
that.
that?
We're going to come full circle. So, but,
Okay.
but but first, okay, this is the strategy. You want to act as dumb as possible. Okay?
Okay.
So a regular consumer, if they ask for accounting, or if they say, hey, what do you mean you want it for your records? You say, yeah, I keep a good copy of my records in case something happens to me or someone else may need to take over the account. I need a copy of the records, right? Just make it very logical. But the thing is, you don't want to alert them of anything because then they start acting funny and delaying everything, right? So you want to catch them off guard. You want to go, hey, I just want a copy of this. I just want a copy of that. And then, okay, so you get a copy of the mortgage documents. Again, we're going to come full circle. So don't worry if you don't understand something right now.
Okay.
You get a copy of the mortgage documents. Then you ask them for complete accounting of the account number that they have. Now remember, these are now two mortgage accounts. Okay. The original mortgage account was closed. That's what's on the contract. You probably wasn't paying attention to that. But the second one that is currently being so-called serviced by the new servicer is a brand new mortgage account. When you ask for full accounting, they will not be able to show an actual transfer of the old mortgage account to the new mortgage account because the old one was actually closed before the other one was open.
So in essence, you don't owe anything. Is what
Exactly.
You're saying, and that's how you show it to the court.
Exactly.
Because it's already been paid off. And they can't prove that they gave you any money.
But wait, you don't want to jump ahead of the horse, right? You have to have all your ducks in a row. So you just keep requesting stuff. So you're requesting full accounting. They're not going to provide that, by the way.
Okay.
Because they know if they show true full accounting, there are several discrepancies that you're going to be able to identify out the gate. Number one is that your payments that you think you've been making is not going towards the account. What does that mean? Remember we were talking about credit earlier and the birth certificate and all that stuff?
Yes.
It's actually documented. So on every account that we have electronically, you'll see a debit and a credit.
Yes.
Do you ever see cash payments actually on the debit or the credit side? No.
I guess not. No.
Exactly. So all the funds that you're moving around and thinking you're making payments and stuff, those are being stolen, and they're using the credits coming from the Treasury Department because what they've done is they've used your actual application to purport and create funds. So all they're doing is moving numbers around different books in order to balance them out. They're not applying any payments to anything.
Interesting. So are you basically stating that all of the money for my home that I've been continuously paying on for all these years is literally not even coming from me?
No, well, it is coming from your account with the Treasury.
But that's not the account I'm funding. It's already there.
Well, what you're thinking is not what's happening. Let's just put it that way.
Fair enough.
Right. So, that's why you want the full accounting, because they have to, if you say full accounting, that means what's seen on the front side and what's seen on the back end. Right?
Okay.
So usually you're
And
only
they're required to show me all
right.
of their
That's
hidden
why you say
accounts and
full
stuff.
accounting or complete accounting. That means
Okay.
everything having to do with the account. Every letter you've sent in, every documentation of transaction, and here's the kicker. This is the third thing you ask for, which again, they're not going to provide full accounting. They're going to send you statements and send you, a stupid listing of everything on the public side. They're not going to show you the private side.
Right. They're not going to show you the double entry bookkeeping.
Right. But that's
Yeah.
fine. That's fine because again, when you don't get what you want, it is your evidence to show their violations. So don't ever be upset that they didn't give you what you want. They're giving you ammunition so you can win. Right? All right.
Okay. Third.
So the third thing you'll ask for, again, if they don't give you something, don't reply back saying, hey, I asked for this and you didn't give that. No, that's fine. You just need a copy of what you sent them and a copy of what you got from them. That's all you need. Right? Okay. Third thing you want is a copy of what's called the money net report. The money net report is this new law that came into effect, I believe, about, 8 or 10 years ago, that states that...
Have you gotten one of those?
No, they refuse to give you that too.
Yeah, I was going to say.
And what's it called again?
A money net report.
Money net. Okay.
It means that any transaction over $10,000 must be reported to the IRS. And that's an IRS Form 8300.
God knows I pay the IRS every year for it. Or, well, taxes for it.
Well, you think you did. But
Yeah.
again, they're bamboozling
I was about
everyone.
to just say that. You think you did.
Right. So now, they're
Hey,
not
Lee,
going to give you that
just
either.
1 second.
Go ahead.
I just want to let you group know, I'm going to step away for a minute. Y'all can talk as long as you want. This channel's open. I'm going to leave it open. But I'm just going to step away, and whenever y'all are ready to shut it down, just log out.
All right, cool.
Sounds good.
Yep. All right, so you asked for the money net report and a copy of Form 8300. That's going to leave them shitting because most people don't know what the hell that is, right? It doesn't only apply to consumers, it applies to every transaction. Anything over $10,000.
Repeat that. Form what?
Form
Money net
8300.
report and Form 8300.
That's an IRS form.
Okay, and you get this from the IRS.gov?
Yeah, you can just Google
Yes.
it. Yeah.
All right, go ahead.
Lee, are you going to tell them about the Form 56 and stuff or no?
Not yet. I just
Okay,
wanted.
okay.
I just want them to get
I
the
don't want to ruin your
transactional side.
presentation because you're doing a really good job. So I'm
Yeah,
not gonna
because I
ruin
also
it.
remember you saying that earlier, Mother Runner, about Form 56F. Yeah.
Yeah.
Right.
Okay, I'll let.
So you kind of want to save the Form 56F for the what you call it, the kicker, right? You don't want that up front because you want them to do some bullshit before you trigger that Form 56, right? You want to catch them in a fresh, what you call it, a fresh violation, so that when an investigation starts, like it's
I
all
want
the
to
way.
catch them in the fresh hell they put me in. Got it.
Right. Exactly.
Is
So
this process just kind of to eliminate some of the litigation when you take it to court?
well, this is before you get to court, right? So
Right. So like when you put them on notice that you're gonna sue them for your property, what you're doing is you're getting the information beforehand, so you don't have to fight it with subpoenas and that stuff later.
well, partially. So let me get back on track because I am going to come around again full circle to answer that question, right? So far we asked for the copy of the mortgage documents. You don't want to say mortgage note or the mortgage contract because they can interpret that in banking terminology and in other freaking stupid shit. So you just want the complete set of mortgage documents. You can't interpret that any other way, right? So that's one. Number two, you want to ask for full accounting. There is no other way to interpret that. It means everything having to do with your account. There's no way around that. Number three, you want a copy of the money net report, right? And you also want a copy of Form 8300 that was supposed to be filed with the IRS as soon as that so-called 100 and something thousand or 200 and something thousand or however amount of money they claim they transferred on your behalf, because that's what is going to be in the language. They didn't give it to you, they transferred it on your behalf. The problem with that is that was a three-party transaction. They did not transfer it on your behalf. They sent it to a title company first or a closing company, and then that closing company is doing something else with the funds. So that's also a lie. That's null and void. But again, you want to act dumb as possible so they can violate, because that's how they do things. If they know you're coming in strong, they're going to try to straighten up before you can catch them in a violation. But if you're acting dumb from the gate, they're going to open themselves up and go, oh, okay, we're going to do this, we're going to do that, we're going to send you this, and they'll give you false information up front, and then you can use that later if there's a discrepancy, or you decide to go after them, or if they come after you. You can show that they've initiated bad faith out of the gate. So the point of any law in any society is you cannot be a wrongdoer of the law and ask for justice. Your claim is going to be null and void. The courts are not going to help you. And that's initially what you're going to be proving in the long run. But before you even get there, right, the information you get that is false, you want to make sure you keep that documentation as close to you as possible. Scan it in as soon as possible. Take pictures of it as soon as possible. Don't ever keep one copy, because we all know anything can happen at any time. You don't want the cat to eat it, the dog to chew on it, nothing like that.
And what is the likelihood, would you believe or think, if I submit for a complete set of my mortgage documents and they actually send a complete set of my mortgage documents,
Zero.
and they're identical to the ones I have,
Zero.
and then it's never going to happen?
Zero.
Okay.
Because okay, so let me give you a full understanding of what you just asked for. If, let's say, this was a scenario and they said they were going to send you something, the original documents was with the original mortgage company.
Correct.
The original mortgage company takes out a part of those documents, and then they send it off with other mortgage documents to a warehouse, and that's now called mortgage-backed securities in a bundle. And now they're sold on the back end as stocks. So each bundle is used as a part of a stock package, right? So
That's pretty shitty.
so they cannot include the entire document package, because now you have two things. Well, first of all, now you don't have the original anymore. And secondly, you cannot have the same thing in two places. So a copy of something cannot be legitimatized as the original. And the courts have ruled on that on so many different occasions. It's basically a maxim of law at this point.
So basically, a copy cannot be legitimized as the original. Yes.
Right, you can't make a claim with a copy.
And that's because they can form multiple lawsuits if they did that.
Exactly. So they can get a judgment, and then the original or another creditor can come back around and say, hey, I have another copy, where's my funds? And they can do it all day. So the courts are not going to allow that. As corrupt as they are, they're not going to allow that, right? So the point is, the original is never going to be complete with the copy. And they know this. This is why they're praying that you throw away your copy that you got at closing, because that's the only way you'll be able to prove that they don't have a complete contract. And if you don't have a complete contract, you can't determine what's called the terms of the contract. So if you can't determine the complete terms of the contract, then how can you enforce a contract without all the terms available to review? Does that make sense now?
Yes.
But
So
what if you go to court and they ask you for a copy of yours? I mean,
No.
it seems legitimate, because
That's
if
not how
you're
it
going
works.
to court,
But go ahead. Let me hear what you're saying.
but like it makes sense, because like I know that I'm gonna have to get a full GAAP accounting ledger on my truck. I already know from the language that they've written me that they're not wanting to provide that.
And that's cool.
So, and so if I can subpoena it from them, which I'm going to have to do, and they're going to have to relinquish it because it's crucial for the case, can't they say the same thing? Well, he has a copy.
No, they can't do that. If you do a discovery in any way, manner, shape, or form, they have to provide their own records. They can't point to another party to provide things that are being asked of them.
And so I mean, I guess what's the premise of like the argument, like
Okay, so
for the court?
so what's the point of them having half a copy and you having a full copy, right? The point of that is if you have the full copy, that means that you have the legitimate contract. If they don't have the full copy, that means that they're an imposter.
So doesn't it have to also, and I guess the other question is doesn't it also have to be wet ink signature for them to
Right.
enforce? And the reason I ask this is because I've read some court cases where they didn't have the copy, and so they applied for original copy, or they did some kind of application to get another original copy.
Yeah, they tried to reproduce the original, right? But there are a couple of things there. Number one, right? The point, again, let me put this in, I guess you could say full circle. If they don't have the original contract and they don't have the complete contract, then they cannot enforce it. And your proof that they are a fraud is that you have a copy of what the contract should be. The case is not going to be about your contract because, again, your contract wasn't signed. You have a blank copy. So if you have the full contract and you know what it's supposed to be, whatever they presented is fraud intentionally because they're submitting stuff into evidence. And anything you submit into evidence, you have to swear an oath to it or affirm to it with affidavit under penalty of perjury. So if they submit
so by
something...
them
That's where they hang themselves on the noose.
Exactly. That's why you have to play dumb from the get-go. Don't try to, manhandle them from the get-go. Because they will notice that you have something that you're trying to, muscle up with.
Mm-hmm.
But if you do get to court...
So, real quick, regarding this, so I was talking to another bank because I have other loans on cars. I've paid off all my car loans with Fiats. And so I didn't want to do business with this company in the first place anymore, so I went to my bank, and what the bank told me, because the loan officer said this to me, he said, I'm not supposed to tell you this, but if you take it to court, you will most likely win. We don't tell people this because it's supposed to be a secret, but most of the time in Idaho, the customer wins.
Well, I would take that with a grain of salt too. It depends on what your argument is.
Mm-hmm. Mm-hmm.
It depends on your claim. Because the thing is, I'm sure everyone here, or most people, have heard of the phrase, show me the note. Right? And there are cases that have been won with that phrase, but that's not what's called a cause of action. That's not something that's actionable to give you a result. That should be a part of your claim, right? So you're going in, for example, to say, well, this is a fraudulent contract, or you don't have a contract. That's a cause of action, right? That's a foundation where something is based on. But you can't go in and use your cause of action as show me the contract, show me the note, or there is no note, or there is no contract. That's not what's called a cause of action. And that's where a lot of people have lost, because they've heard that on the news, or they heard that in passing, and they go use that and they end up losing. And you have to be very careful, because if you lose, for example, on a contract, right, you can no longer bring that up in court again. You can't ever bring that back. They're going to bar you from using that same cause of action related to that contract.
So I got one question for you, and I want to kind of get back to the other subject, but I have one question for you real quick. So I have a demand judgment against Westmark. That's the credit union that I went through, where I wrote them a notice. They failed to respond. After 30 days, another notice, failed to respond, until eventually I had a judgment. I have withheld using my judgment, but my question is, can I take that judgment, take one aspect of it, and use it against them? and sue them for solely that just one of the things for a civil action.
Oh, okay, what was that was that based on an existing contract that you sent those letters?
Yeah.
Okay. No,
Yeah, because
no, you cannot.
I told them, what's that?
No, you cannot.
Or do you have to do the whole thing and use it?
Anything that's based on something fundamental like a contract, it's it doesn't matter how you come about it or how many causes of action or how many things you're claiming that's based on that contract, it's still one contract. That's number one. Number two,
Okay. Because the reason I was asking is because I wanted to separate the GLB Act from that and then reporting to the credit unions after I wrote to them and told them to stop reporting. I wrote to the credit bureaus. I said, this is in litigation right now. Stop reporting. And they haven't stopped reporting either.
so you have to sue them. Well, they can't stop reporting per se, but they should be able to put either a freeze or a hold on something, or stop reporting anything new on it, but they can't stop reporting it altogether.
Yeah, because they and another thing is since I put them on notice, and I even told them essentially this is a billing error dispute because these matters were not resolved, and you're continuing to add money to the account. They're like adding more debt to it.
Yeah, because when you do a billing error dispute, it's for a certain month. It's not perpetual. It's
Yeah, but
not,
then you're until they are able to. Maybe that's why it shows I paid 1 month that I didn't pay on.
right. So you can dispute every single month. Every time a month comes up and you get a statement, you can dispute it. You say, hey, I believe there's a billing error, and you can keep doing that every single month. But then you have to figure out another way, because then they can say it's an abusive process. So that's not you can use it a couple of times, but you can't use it as a strategy.
Right. Okay, so back to what we were talking about with the mortgages, and also one question about the coupons. She said you use the IRS to enforce those. So I have the full coupon book according to their pamphlet of the servicer. First of all, they told me that deferred payments aren't allowed ever. On you can never get a deferred payment on my loan, is what they said.
Okay.
And
is that in writing, or
is
is that over the phone?
It never says anything like that in my contract. That's over the phone, they said.
Okay.
So should I ask them to send that to me in writing?
Well, what are you trying to do when you say defer payments? Are you telling them you're in hardship?
Well, I told them I needed just to skip 1 month, and I asked them to attach it to the back of the loan.
Oh, yeah.
Because it was the same month where I had that surgery, which started the process with my truck. But instead, I've had to give every penny I have because it's attached like these crazy amounts to it every freaking month, and then when I pay it, they add more to it, and so I'll finally caught up. But my whole goal in the first place when I bought the house was to court. I was very so.
You're dropping out for a second. What was the last part of that? You said the whole point of what?
All right, you're breaking really bad.
Oh, maybe it's my connection.
Oh, maybe.
Can y'all hear me?
I can hear you.
Oh, looks like they're jacking up my connection. Can y'all still hear me?
Yeah.
Everybody's going crazy. Like, stuttering
Yeah.
All right, I'm gonna
All
drop
you guys
and
are
come back.
breaking up.
All right, can y'all hear me now? All right, can y'all hear me now?
I can hear you now. Yeah.
There you guys are.
Okay. Yeah, I don't know what happened a while ago.
That was really weird. It was like across the board.
Yeah, they probably picked
Yeah.
something up on the line and go, hey, let's cut them off.
Yeah.
That would actually seem feasible and wholeheartedly accurate.
Right.
I honestly believe that myself. I mean, I've seen it enough. Interestingly, when I'm talking with my dad about anything that has to do with government conspiracy, the calls drop.
Yeah. Of course. I don't want you talking about that.
Yeah. Right.
All right, so you had another question
So
about
anyways-
the mortgage stuff, or?
Yeah, it has to do with the coupons. One question before I ask the question though is, have you done this, or are you in the process of doing this, or?
I've done the coupon thing, but I was not successful in the way of having them accept it. But I had another strategy behind that. So
So did you win your house or no?
did I win my house?
He's
Yeah, like-
basically asking, how do you know all of this information? Like, have you done something that was successful, or do you have like a law degree?
No, no, I don't have a law degree. I don't have any of those so-called credentials. But what I do is I read a lot. I study court cases, and I have done my own processes to be successful in some things. But I have not done every single thing as of yet. I'm in process. Also, my mortgage stuff, the way I knew about all of this is from reading from cases that people have lost. I read what the judges say, because oftentimes the judges will tell you why you lost and what you didn't do. So, based on some of those things, I've put together different strategies on how to approach certain situations, and also from dealing with the banks, asking them certain questions, acting dumb, recording them, keeping track of things, and also helping a couple of people with foreclosure. So that's how I got my knowledge.
Have the people with the foreclosures had any success?
Absolutely.
I guess the other thing is, it sounds like you're in the process of doing this for your own self right now.
Yeah, well, I'm in a completely different process with the bank and my mortgage. What I'm trying to figure out is how to initiate an action with the bank, not against the bank, with the bank, without going to court and without, falling on arrears with the bank. So basically staying in honor and keeping everything afloat and still get remedy without having to be adverse with the bank and fighting and going through all kinds of different crap.
Yeah, because I've seen all the court cases that I've seen that have won and they got their house mortgage removed, all of them have always maintained payments
Right,
through the process.
right.
Because
So
I
do you
think the
think
reason
that
for that is
Both
because
of you, well, since both of you have obviously, Lee, you're still maintaining your payments, and Joe, you've obviously seen court cases that were won by people that had maintained their payments. I've maintained all of my payments. It's just I have tried to dispute these extremely excessive fees that they've attached to it, stating, and there is no definition. The only thing that it states on my mortgage payments is that if there's a late fee, it's like $35 or something like that, right?
Right.
But I'm not late because I'm paying it prior to the month that actually the payments due. My payments are due on January 1st, the first of every month. So December 15th, I get my money and I pay them that same week of the 15th of that month prior to, and they're still attacking me with crazy fees.
All right,
And
so
I've been paying those fees.
let me stop you there for a second. Joe had a good point, right? So earlier when Joe said that he tried a billing error dispute, right? And that worked for like a month, but then nothing happened later. That's what you need to do. You need to do a billing error dispute. It doesn't matter if it's just the fees. It's still a billing error. And you don't understand what this is for or why they're charging you whatever fees they're charging. Right? So that will basically nullify that month of fees and mortgage. Not just the fees, it's the whole thing. And you can do that going forward if you know for sure that, or if you believe that these fees are unconscionable.
They really are. Like, I know that my homeowner's insurance premium went up, as majority of America's did, and so I accepted that when they told me that my escrow was increasing. So my payment went from $1,300 to $1,500 and some change. But now it's almost $2,000 a month, and they're literally just tacking on fees. And I told them I've done the billing error dispute since June. I've also asked for clarification as to what these fees that they're attacking my livelihood with, basically, and I have gotten no resolve. And
So
now
did you ask
they're
him?
literally-
Did you ask him on the phone or by mail?
Man, I wish I had your mortgage.
Well, I got my house in 2015, and I got an extraordinarily low rate. I'm at 3.5%.
Nice.
So, like, my house is a very large farm. Just because I've lived here so long, I could literally sell my house for 2 times what I've actually bought it for, just because of where I'm at and where I'm located. But despite all of that, like, I didn't agree for my mortgage to get sent to this new servicer, and I definitely didn't agree for them to just attack me with fees. Like, I'm talking a low end of $9,000, just a smidge over $9,000 is what they're looking for in fees since June. I don't even understand how that's even like a normal amount of fees.
Right. So that's why I gave you those steps, so you can.
And I've got them all.
Yeah.
Complete set of mortgage documents, complete accounting, and then the money net report with the IRS form 8300.
Right. Just remember, you're doing one at a time.
Absolutely. Now, I did have one question. Am I able to send one and then, like, do I have to wait for a response
Yes.
before I send the next one?
Yes. I
And
know.
would you guys both advise that, like, maybe I just pay the 9,000 and it's, let's just say 9,100, so
No.
I'm 100% current, so they can't try to default me before? Because I know if I send something in written communication, they have up to 30 days to respond, and those 3 steps would be
Well-
90 days out.
Well,
So the reason I was trying to tell you the whole sweeping your payments on time and those people at once, and this is how I see it when I'm reading the court. It seems like to me when I'm reading the court cases where they won because they keep paying the payments, and then they have an issue and then they take it to the court and they win, is because it's not like you're doing it out of desperation because you don't have the money to pay. You're obviously paying, but there's a problem here and you just want it fixed.
right. So what you want to do is, well, the question is, where are the fees? Are the fees attached to the actual mortgage statement, or is it separate?
So it is in the mortgage statement. So, like, when they make the mortgage statement, let's just say that they prepare it on the 2nd of each month because my payment's due on the 1st, right? By the time that I receive the mortgage statement, it states, even though by this point, so they make it on the 2nd for the current month, I've already made my payment the month before for this current month, okay?
Right.
So just keep that in mind.
Mhm.
So now I get my mortgage statement, and it clearly states on my mortgage statement that I have, here's your principal, here's your interest, here is your escrow, all of the above.
Right.
And then moving forward, it states, as I'm opening a brand new one, if I can give you a verbatim, other accrued fees.
Mm-hmm.
And then it says accrued late charges. So they're double dipping on me because I get accrued late charges and other accrued fees. And literally, I'm not late. I literally pay bare minimum 1 week in advance, and I send it certified with a tracking number, or however the most appropriate way I can send it without it going to an actual person, because they only accept payments in a PO box.
Right. So, question here: when did you first notice that they were tacking on these fees?
So these fees have been going on for a while. I got this resolved a long time ago, well before my payment ever went up.
I have cancer. I got really, really sick. So I felt I wasn't working as much and I fell behind on my payments. And I found a government program that would help me catch up on my payments and all this other good jazz, right? So ever since I was 100% paid in full, back working and doing all this other stuff while I'm in remission, fingers crossed, everybody.
Yep, that's great.
But the very first payment I was supposed to make after the government program caught me up. So after I got caught up on it and everything is kosher and I'm getting ready to make my very first payment again, that is when all of the accrued fees are there. It's just like they tacked it on to all of the months I wasn't there and the government program handled everything or something. Mind you, I only got 4 months worth of government assistance for this loan of mine. And then I made my first payment with them and it was that next, it wasn't even the next statement because it came out later that same exact month
Okay,
stating
so
all of these excessive charges and fees.
so basically what you want to do then is you want to find that first statement that started to show these so-called fees, right?
Okay.
Once you find it, you want to basically document. So basically from that point on, it's been showing up.
But
on
I
your
also
statement.
have numerous months where they didn't send a statement.
That's fine.
And that's online and that's in mail.
Okay, good. So you want to document all of that, but the important thing you want to document here is when you saw the first spike in these so-called fees, right? And you want to send, as a matter of fact, you just want to notate the date on that, right? The date of the statement that shows the excessive fees. And
Okay.
the current month or the upcoming month that you need to pay your mortgage, right? You want to know, because it's still on your mortgage statement, right?
Yes. And the month that it all went up, I got a middle of the month thing with an adjustment because I guess they did some sort of different accounting because it went from the government making a payment versus me making a payment. So I
Right.
got an updated adjustment for it.
Mm-hmm.
But I never got an actual statement for that month nor the following month. And there's nothing online on my account either. And they've actually restricted me and blocked me from making any kind of a payment online. And I'm only restricted to seeing my actual statements online and nothing else about my actual mortgage itself because they have me claimed as in default.
Wait, what's it? Wait. What's saying in default?
My Service Solutions, my mortgage servicer people.
Okay, do you have that in documentation?
Yeah, they sent me, they sent me a letter in the mail that came back stating, we noticed that you're severely behind on your mortgage payments. You don't have to lose your home. That's not what we want. That's not the only option. And then they sent me a lot of forms to try and mitigate the solution, essentially.
Right, but does it say actual default on any of those things?
Let me look. I don't believe the word default. I just believe it clearly states that I am since June behind. So this would be the 4th month.
So Lee,
Mm-hmm.
I guess from what I'm hearing from both sides is I'm thinking Alexandria wants to know what her very first step should be.
Right, yeah, that's what I was getting at. But, before we get to the steps, we want to make sure we have enough information and the correct information before you, do
Absolutely.
something. Because one of the things is,
The most recent statement I have here does not state, it states a delinquency notice, but it doesn't state that I'm default.
okay, what does a delinquency notice say?
It says you are late on your mortgage payments. Failure to bring your account current may result in fees and foreclosure, the loss of your home, and the loss of your home. As of the date of this statement, you are X amount of days delinquent on your mortgage, and it states 76 days. And the date of this mortgage statement is August 16th because I don't have September's yet.
Okay, so did you, and you're saying that you've never been late?
No, sir.
Okay.
I mean, I did get behind, which is why I went through the government program. But since June, I'm not behind. I make all of my payments every single month exactly, and without even getting statements, it clearly stated on my mortgage statements that my payment was 1,300 and some change, and then it went up to 1,400 and some change, and then it went up to 1,500 and some change, literally month to month to month. And then now this statement is the first statement I have that clearly states that it is now over $1,800 a month.
Okay. So
Do you have enough money to hire a lawyer? Because that sounds like a simple thing that our attorney could just write a letter, and you won't even have to go to court. And they'd be like, you know, the government paid this. We have the proof. You need to remit.
Well, the worst part is that they tried to screw the government program over on me. And it literally took weeks for it to go through because I told my servicer exactly what the dollar amount was that I was allowed for the program, and that it would clear my debt balance because of what they had specifically told me for weeks. And they then submitted to the government program that exact amount, and they tried to tell me it was the amount that was owed plus 1 month of my mortgage, when in all actuality it wasn't. It was only like $600 and something over what my actual debt balance was with the mortgage company. And it like denied me. I got denied from the program, and I had to go through all these different hoops just because they tacked on an extra $600 and something for no apparent reason whatsoever. They tried to confirm the fact that it was because of the sheer fact that they were adding an additional month's worth of mortgage onto the program. And I was like, well, that's not what I was qualified for. I gave them the numbers that you guys gave me, and that's the numbers I was qualified for, and that's what they're paying.
okay, so this is why we do not
It was a rough go.
we do not speak to the
It
bank.
really sounds like to me that they know your home has doubled in
Of
value,
course.
and they're just trying to do what they can do so they can triple their money.
Exactly. And
This is what it sounds like.
well, the other thing that they're trying to do is they're trying to get you to agree that whatever you're paying now, whatever they've done, is valid. So if you don't contest it, or you don't know how to contest it, then they're just going to steamroll ahead.
And they've also increased my escrow portion of my monthly mortgage payment to over $1,000 a month, when in all actuality, my homeowner's insurance, the only difference apart in my escrow would be my homeowner's insurance.
Wait, what
And
about
that would
taxes?
only be- well, the taxes, those did go up.
Right.
But I have a letter from my county that I gave to my mortgage servicer, and I told them this is what my fees will be for the following year. So that's appropriate on my statements, and that's all in line. The only difference is my homeowner's insurance went from like $1,800, $1,900 a year to now almost $6,000 a year. But
Holy cow.
Yeah, that is a bad go. And I'm not even in a flood zone or anything like that. And
So
I've never
my-
made
my
a
home
homeowner's
is-
claim.
So did you speak
My
to
home
the
is,
insurance company about that?
300.
I did, but at the time that it all transpired, I was literally undergoing chemo treatments and radiation treatments, and I didn't have it in me to fight for another company or to get those reduced. So I just let it go through for this year, and I just said, screw it, I'll deal with it later. And I accepted that increase. But the increase from my homeowner's insurance, so the difference should have been X amount of dollars added to my escrow account each month. But in reality, they tacked on like an additional $600 because they're preparing for an additional increase on my escrow, because my mortgage servicer is anticipating that my homeowner's insurance is going to increase to X amount for 2025. So they're billing me this year
Right.
for 2025, which is, that's fine and dandy, but $600 a month is not okay.
Right. Okay. So let's slow down here. A couple of things going on. I can see.
I feel like I'm just royally fucked, and I also still am coming out of chemo brain. I'm not 100% normal brain anymore. So like,
Well,
that's why when I found you guys, I was like, I'm in the right place.
well, I mean, you're recovering, you're in remission, so that's gonna count for a lot. You know, you'll get your wits back at you. But the first thing you do need to do is start getting those documents together, create them all at once. If you can't write them by yourself, use ChatGPT. That it is great at crafting documents, as long as you put in the parameters of what you want, right? If it doesn't look like what you want, you go back, you give it a new set of instructions, and it will recraft your document for you. So ChatGPT is good for
Okay.
that. Don't let it give you citations. It will screw you.
Okay.
Yes.
No.
The other thing is, with your insurance, you definitely want to call around to different insurance companies and try to see what their quote is, right?
I have been doing that, but my mortgage servicer also clearly tells me that if I cancel my homeowner's insurance and replace it with another, that they will not cover that through the escrow, that I need to pay the entirety of a new insurance
Listen,
company up front.
don't ever listen to your servicer, your mortgage servicer. They're
Okay.
idiots. Okay,
Okay.
whenever
But
they're
I
getting a
didn't
bulk
have
of
the,
money,
$3,000-$5,000, so.
yeah, if they're getting extra money,
So
they don't
my
want you to
mortgage
change.
servicer, regarding what you just said, don't listen to them. I'm a bit confused because they told me that first of all they tack on like $150 or something like that on top of a $2,500 monthly payment if I'm late. But my contract says that it should only be $65.
Okay. So what you want to do
Yeah.
is you want to ask them again. Don't ever talk to them on the phone. It's you don't have a record of it. Half the time you would have to transcribe the whole thing anyways. So just send them a letter in the mail saying, "Hey, I would just like clarification on where did you get the justification for charging me this?" And you're done. Send it off, certified mail, track it, make sure they get it, print out a copy, keep for your records. So whatever they're coming back with, if they come back with bullshit, no problem. Is that the other thing?
Because if you don't say something, then they'll get a judgment by acquiescence.
Right. Because again, like I was telling I was telling Zach earlier, the law is active. You cannot stand still and get justice. It just won't happen. You have to move. You have to do something. Now, the other part of all of this is that you can have all the evidence in the world and you can threaten them all you want, but you have to be willing to go all the way. They're willing to go to court, and so should you. You don't have to know law.
Definitely willing to go all the way. This is my house. And ironically, possession is 9/10 of the law. And yet,
Yeah, but
yeah.
be careful making that argument though, because it comes from a French term and it doesn't really apply to America.
What?
There is it actually goes all the way back to the Roman days.
Wait,
but,
what are we talking about?
Possession is 9/10 of the law.
Oh,
It goes back to the Roman time period, and it's just a way that they litigated back then in their court system, and it's not really applicable in today's court.
it actually is.
They've twisted it. You have to go through like a process.
There is a process, but it is still 9/10 of the law here in America.
It is.
100%.
And I'll tell you why.
That's because America is grown.
Right, and the reason for that is, because the bank doesn't own your property. The bank doesn't have a right to sell your property. What's happening is the bank has what's called an interest in the property. So they can lay claim to a part of the property because of the interest. But there are ways to circumvent that. And one of them is, if you have a current private dispute with the bank, they cannot just drag you to court. Because if they do drag you to court and you have evidence to show that they have unresolved issues and they're trying to drag you to court to abuse the court's process, then you automatically win.
Could you elaborate that topic right there just a smidge?
Yeah, basically, possession is 9/10 of the law, and that's coming from Roman times. Joe's correct in saying that, and that has not gone away. So basically, the way to circumvent that, with the whole court process thing, that a lot of these banks love running to court because they know that we don't keep proper records. That's why I told you to get all those records up front. Once you get the records, it's easy to do a dispute, to say, hey, I don't agree to this. What is this? Where did this come from? How did you get the authority? Like, you can go unlimited. Every single month you can challenge something. So if the bank decides that, oh, you're trying to abuse something, or you're doing whatever, you're lawfully inquiring about an account that has your property on it. Your name is your property. So the bank cannot deny you access to your own records. They can, but if they do, and they try to go to court, they're automatically going to lose, because
What would be the motion to dismiss? Like the language used, motion to dismiss.
no, you wouldn't do a motion to dismiss. You would ask for a summary judgment. You'll claim damages. You can't. Okay. Let me answer your question. Yes, you can do a motion to dismiss. The dismissal would be based on the bank is acting in bad faith. They're trying to circumvent the laws of private contracting and using the court in a public venue to defraud you. Because essentially what they're going for in a court is to take your property.
Right. I wanted to get your thoughts on this, Lee. So when you're a part of a credit union, right? If you're an account holder in a credit union, you're part owner because it's a union, correct? And they even tell you that it's owned by the account holders in their websites.
That's not necessarily true, but go ahead.
But at least the one I'm fighting is listed right there. Account holders, it's solely owned by our account holders. They take pride in it.
Okay.
So if Westmark is suing me, and I don't know if this is going to be like a really tricky thing, not a tricky thing, a really sly thing to do, I suppose, that might give me some justice. But I was planning on making a motion to dismiss when I get to the courtroom, based on the fact that of conflict of interest, because I can't sue myself for my own stuff.
You won't be able to make that argument.
You think it wouldn't fly?
Because you're a shareholder. You're not an actual owner. A shareholder is not listed as a party to a company.
Well, so how they have it written on their own website, and I could take that in the court too.
Right.
They said, we are proudly, at the top of it says, proudly owned and operated by our account holders.
Okay. Now,
So wouldn't it be a conflict of interest to sue myself? And then I would open myself up to insurance fraud, because then I could claim insurance on this contract that had no performance.
okay. So I'm going to play devil's advocate like I do all the time. All right.
Sure.
So you're claiming that you're a part owner of Westmark.
Right.
Okay. Can you prove that?
Yeah, with your website
Okay, the website
and my account number.
the website is
Because I have a savings account of $5 in there.
right, that's fine. But hold on. We got to go one question at a time here. So you have an account and an account number, right?
Right.
And on the website it says the company is owned and operated by its shareholders or its owners.
What is the exact website's verbiage?
So
Right.
let me look at it real quick.
Because, all right, while you're looking that up, okay?
Okay, hold on. Like I say, who owns? And I came to this realization because I was trying to find out who to send the letters to.
Mm-hmm.
So then this is how I came up with it. not Western Union. So, Westmark Credit Union has been helping the people of Idaho grow financially since 1954. We are a full-service financial cooperative entirely owned by our members and committed to the development of their financial future.
Okay. So what is the definition
That's
of
their
members?
tax verbiage.
Oh, okay. All right. Let's not even go any further. So it says owned and what? Operated. Right?
Yeah.
That's a trick. What's the trick? The trick is it says owned and operated. Have you operated in any capacity in that company?
Yeah, it's financial benefit by making payments on that contract.
No. You need a function. You need a title. You need something. You're not employed by the company. You're owning like feathers on an eagle. That's not owning and operating. And I'm not saying that to be facetious or,
No, I get
discourage
it.
you.
No, this is just to provoke thoughts.
Right. So if you're
So we don't lose, because we know, you and I, we both know that those lawyers, they're trained. They've been to school for many years.
right, and trust me, they will go down that
we're
road.
We're coming in with a slingshot against Goliath, essentially. You know?
And we have to be very mindful of how we aim. Right.
Right, exactly.
Touche,
We're trying to take out the
touche.
crown. You take out the head, the whole thing falls to pieces.
Right. So, but with that argument, you don't want to come in making statements. You don't want to claim anything. If you were going to go down that route, right, just to test the waters, you can ask him. You can say, hey, what exactly does this mean? Because you're saying owned and operated by shareholders, or however way they put it. What exactly does that mean? And you can ask him before you get to court. You can say, hey, the website is saying this. Does that mean I'm an owner operator because I have an account? You can ask him that, right? And they can think they're joking,
Right,
and they can
like admins better.
and they can say, yeah, thinking it's a joke. But when you go to court, you can use that in your ammunition to say, hey, there's no way possible in any court of law that I can sue myself or a company can sue itself. And being that I'm a part of a company, under what grounds am I subjected to a lawsuit? And that could be quashed. But you need that evidence.
And it would be instantly dismissed.
Right. But you would have to trick them into saying that.
Yeah, so that they couldn't twist it.
Right. It's their own words. So you say, by the admission of the plaintiff, I am a party to this to this company, and a company cannot sue itself. No entity can sue itself. So therefore, this is an invalid claim. Failure to state a claim upon which relief can be granted. Move for a motion to dismiss.
Hey, Lee, I kind of got to get off here, but is there any, are you okay with me messaging you privately?
Oh yeah, that's cool.
Like outside the group, so I just get some specific information from you?
Yeah, that's fine.
You're kind of a sharp guy, and I like that.
Yeah, no problem.
All right, you guys have a good day.
All right, you too. Yep.
Bye, Joe.
Bye-bye.
Okay, back to you, Alex.
I know if you are anything like me, you are probably dying to complete a full circle, aren't you?
Well, I try to be very meticulous in whatever I do and just go, full blast.
You and me both, but like when I am trying to close a full circle and then like I get squirreled off onto a different tangent or a different path and I have yet to complete that full circle, my brain just explodes.
Right. You just want to get that completed. Yep. Yeah, so, all right. Where did we leave off on? Oh, yeah. So I was saying, before we do anything, right, we want to get the documentation, and we want to ask them for clarification on where these fees come from. So you can send two letters at the same time. One, you can request the mortgage documents, and then in another letter, maybe 2 days later, you can send another one to say, hey, I have a question about these fees. Can you please explain in detail where they came from and how are they justified? That's simple.
And even though I've already done that on the phone with them,
Yeah, the phone
just
doesn't
doing it in
count.
writing would be secondary.
The phone doesn't count because you don't have a record of it.
What if I may or may not have recorded it? Because here in my state, recording permission is not required.
Okay. So what did they say?
They basically told me, like, just to go back to the previous example that we had spoken about, just to make it short and sweet, they clearly stated that they had added an additional month's worth of a payment in regards to what was requested from my program, right?
I would get it in writing because transcribing it and then trying to make a claim from that is going to be difficult.
Okay.
You can't submit audio in a court in a court hearing. You have to submit the transcript, and then if the judge requests to hear the original, then you can provide the audio.
Okay. But just like but for instance, for this purpose, is they told me it was an additional month's mortgage.
Mm-hmm.
But in reality, the mortgage at that time was not $600. It was never $600.
Right.
Plus a little over $600. So then when I spoke to multiple different people, have it all recorded, the lady stated, the last lady I spoke to, I guess she must have been the highest up. She was the one who had stated, we've already removed it and resubmitted it, and that's all that they would give me. Nobody would ever tell me how or why an additional month was added, let alone it wasn't even half to cover 1 month of mortgage.
And that's why I say send something in writing, because all they can do they can try to call you, but you can tell them, listen, I need a physical copy of whatever you have to say because I need it for my records.
Okay.
That's it. Don't stay on the phone with these people. You're going to waste your time.
So a question to piggyback off of what you were speaking to Joe, I guess, about. He had stated, or you had stated, that if you're in, like, if I'm disputing something with the company before any type of legal actions were to arise, so like if I'm starting to request these documents and telling them these things aren't true,
No, you're not telling them anything.
Okay.
All you're doing is asking questions and getting documents and getting responses. You're not telling them anything. You're just asking questions.
Okay. I just feel like I found this group a little late because I'm already at that mark where they could potentially do something about it. In all actuality, I'm 100% up to snuff on everything. I paid everything just as I was supposed to. Even the increased amounts that they demanded from me, the only thing I didn't pay was their accrued fees and accrued late fees when nothing's been late. And they just haven't stopped tacking them on.
And that's fine. And they cannot just foreclose on you because of fees. The mortgage is completely separate from fees. Are not a consequential item, right? So
they can't come after me in a legal aspect because of their stupid fees.
No.
So this is something that I can deal with them on one-on-one, but because they keep sending me notices about, like, oh, you're seriously delinquent and you may be facing foreclosure.
And that's why I say send them a notice or send them a request to say, hey, can you please explain what this means? You can even, whatever question you have, don't ever tell them, hey, you send me this and I don't know what this is about. No. Make it short and sweet.
Fair enough. Short and sweet.
Yep. Just say, hey, what is this and why did I get it? Like that delinquent notice and you're behind and whatever. Say, hey, I do not believe I am delinquent. What is this? What is it for? That's it. Okay. Don't make a long letter. Don't accuse them of anything,
Okay.
Because that's where you go wrong, because now you're making you're basically coming to conclusions before you're asking the questions.
Okay. Because as of right now, like, I'm not getting any phone calls from them. I just know September is the 4th month, which in my state, legally, they could act
No,
on that.
they can
Or
only
take me
act
to
on the
court.
mortgage. They cannot act on
Well,
fees.
that's the hook, line, and sinker. Is that every penny I have paid, they are holding in a separate reserve account
That's not your
until
problem.
they deem that I have paid everything in full, and then they apply it to my mortgage. I am making my monthly mortgage payments the month before they are due,
Right.
and they're not applying anything, and they're literally going to try and take my house from me.
Wait. Okay. So let's back up here a little bit. Okay.
Okay.
When you read your contract, they said they were gonna, if you make partial payments, they're gonna keep it in another account until it
Yes.
reaches the amount necessary to pay the mortgage.
Yes. And this new servicing company that my mortgage was sold to deems all fees and all principal, interest, and escrow are required before a payment would be applied.
And that's fine.
But that is not in my contract though, but that is what this servicing company is basically and essentially telling me without anything in written format. It's all verbal over the phone. But
And that's
they're
good.
telling me that they will not apply my funds to my actual mortgage unless I fulfill the entirety of that payment. And that payment includes thousands of dollars in excess of what my actual, like, keep this in mind, from June till now, they're looking for a little over $9,000 in fees that they won't actually explain to me what these fees are.
Right. So again, we're going circles here. That's why you're asking questions. And just for your comfort, as long as you are making some sort of payment, it doesn't matter if it's not full payment. It doesn't matter what they're doing with those payments. You don't actually know, even whatever they put online, you don't know for sure what they're doing with that. So you don't care. You are still making payments as you can, right? That's the truth.
Yes.
So you don't care about what they want to do with these payments or how they're applying them or whatever the case may be. You are making payments. That's the fact.
Okay.
What you're concerned about is, what are these fees and why are you getting this notice? And they have to answer you. You can't have controversy and go to court. That's active, right? This is not something where you're in dishonor, not making any payments whatsoever.
Okay.
So just
So you don't believe I should have to pay the excessive $9,000 of fees that nobody will explain to me for?
no, if they're not explaining them, then why would you pay them?
Okay. They just keep putting me on hold. They just keep putting me to another person.
I told you.
this and that.
Stop calling them.
Yeah.
Stop.
Well, I just found you guys like 2 weeks ago, so I didn't know any of this. I was just trying to do what I thought was right. You know what I mean? Like, I've
Right.
been making the payments, even their unexplained adjusted increases in my payments. I don't have a balloon payment. I have an FHA loan. Like, my stuff doesn't change, right?
Mhm.
And I've never refinanced or home equity loans. Like, it's just a normal one loan on my house, and I've always done exactly as I was supposed to. It's just now I feel like they're trying to put me in fear of God that I'm not making what they deem I pay, and they're going to try and take
all
me
right.
home. And this is a children's home, so
All right. So let's fast forward ahead, if you will. All right. Let's, again, theoretically speaking, let's say you end up in court, right? They're like, oh, you're not making the correct payments and we are accelerating the loan, right?
okay.
By this time, you would have already gotten the paperwork that you need. But let's say you didn't. Let's say you have nothing, right? And you're wondering, what the hell? You know, my home is in jeopardy, blah, 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 blah. Here's another strategy that you probably won't hear anywhere else. Number one, fine, they want the house, right? You don't know any
Of
legal
course
thing.
they do. Tripled in value.
Right. You don't know, any legal avenues or whatever to do with all this court situation. So what do? Just like in the Bible, it says, agree with your adversary, lest they throw you in jail and take your property. All right. What you can do is you can tell them, I agree with you, right? I agree that your claim or your bill is valid, right? On the condition that since you are taking the property, you hereby return all of my property that have been given in return for this property. That includes your mortgage note, which is the security they're trading on Wall Street, the original.
Okay.
That includes all the payments you've made, including taxes and insurance. That includes all of the improvements you've made to the house, if any. And that includes your personal labor that you've invested into the property, cleaning the property, keeping the property from overgrowing in vegetation, mowing the lawn, paying for whatever it is, gas, electric, every single thing that has happened since the start of the contract, you're claiming back.
Okay.
Nobody can say that's invalid, not even a judge.
So basically, if they seek to take my home, I agree, and I state
Conditionally.
that they need to.
It's called
sorry?
a conditional agreement.
A conditional agreement. Okay, hold on. I'm gonna write that down because my brain's not the same.
For acceptance, right, Lee?
Say that again,
What's
Luke?
that?
Conditional acceptance.
Right.
So my conditional acceptance, if they do take me to court, is that I essentially am asking back everything I've paid to the lenders for my home, property taxes.
No.
Interest.
You're not asking back. You're saying this is the new agreement because basically they're changing the terms of the contract. They're accelerating the
Okay.
loan. They're basically saying this is how we wish to end the contract. You don't
Okay.
have to accept that.
New offer.
What's that, Luke? You're breaking up.
It's a new offer. We're offering you something different
Right.
than you originally. But what you're doing is it's sort of like in contract terms, you're having a meeting of the minds, saying, "Okay, I'll agree to your new offer, but here are the stipulations."
Exactly.
And their new offer is executed at court, I guess, or something?
Well, that's where they'll try. They're not going to send a foreclosure offer to you to accept in the mail. They're going to try to enforce a foreclosure through the courts,
Right.
right? And if they go to court, you don't want to be in there combative, trying to say, hey, they're trying to take my house. I don't agree to this. Da, 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 da. Well, of course you don't agree to it, but there is another way to
Right.
do it where you're agreeing to the terms. And here's the trick. If you agree before the judge can say anything, there's no controversy. There's just an unresolved contract that's active.
So basically, they're in front of the judge stating why they want to do a foreclosure for some obscene amount of fees and crap like that. Like, I don't even understand how $9,000 since June in fees is constitutional, but here we are.
Well,
So,
yeah, I mean, you don't want to get into, the details of whatever they're claiming, right?
right.
You just want to say, fine, you can have it your way, but here are my terms, right?
Okay. And this all stems from them telling the judge why we're there
No,
and before
no.
the judge makes a ruling.
It starts by them filing a claim and you getting notice that they are, well, is it a judicial foreclosure state?
I don't know that. I'm in Missouri. I don't
Okay.
know if it's a judicial one or not.
Because there are some states that they're not required to go to court to start a foreclosure. They just have to send you
Okay.
notices in the mail. So if you're getting something in the mail saying that, hey, we're going to start foreclosure on your property, blah, 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 then that's when they're trying to close on your house. So if that happens, then you have to go to court as soon as that happens and sue them, basically, to what they call stay the proceedings, the foreclosure
A stay
proceedings.
order.
Right.
Okay.
So either way, you end up in court, but then you'll get to see what exactly they're trying to do. They have to submit the documents that they're claiming is a valid contract, and then you have a chance to go multiple different routes. But if you don't want to do the whole legal thing, you just say, hey, you know what? I agree with you. You can have the home. However, I only accept that offer if you return to me all my rights, titles, interests, and property, including blah, 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 blah. And you also itemize a bill to say, hey, over these 10 years, I've done, these improvements to the property. I've invested this amount of time. I've done this and that. And this is my fee that I've calculated to be just and proper, for employment of the same. And here's my bill. Here's the amount that would be owing if you choose to go forward with this, because I'm accepting the terms based on these conditions.
And so if they don't accept my terms that I put forth, when I accept their terms, then what would happen?
So it's both. It's what's called an offer. They're making an offer, and you're coming back with a counter offer, right?
Okay.
If they say, if they come back and let's say they reject it. Let's play, worst case scenario. They reject it and they say, well, we're going to foreclose to satisfy the mortgage, right? The first thing
Fair enough.
the first thing you're going to do is you're going to say, fine, Your Honor, I would like, or you don't really want to talk to a judge.
Okay.
They're emotional. They're idiots. Yes, they're smart in what they do, but they're often very biased.
Okay.
So you want to always file your paperwork. So you would file something like a bill of particulars. And a bill of particulars is basically a document asking questions and requesting documents for discovery. You want to discover documents that are in the possession of the other party that is valid for your case. Right? So whatever you ask them for, they have to, if they're not going to provide it, they have to provide an affidavit to say that either they don't have it or they don't wish to contest what you're saying or what you're asking for. They can't just not respond. This is not, civil anymore. This is now basically a public venue. Because anyone could look up the court case and see all the details. So when you do that, then you put them in a very bad position, because not only do you have a copy of what you got from them earlier, now they're pressured to submit the same documents they sent you.
Okay.
And again, if you ask for full accounting, if you ask for the originals of anything, if you ask for the money net report, the 8300 form that they should have filed with the IRS, they will not have those things, and most likely they'll try to settle out of court, or the judge will dismiss the case voluntarily, because the judge will also implicate themselves if they try to move past an IRS documents request.
Okay.
Because everyone has to pay taxes. Doesn't matter if you're a government or not. You have to pay taxes.
So let's just say I'm that unlucky bastard, because my luck, I feel like, ran out a while ago. So let's just say I'm that unlucky bastard and they procure all documents that I request, including the IRS form 8300.
Uh-huh. Okay, let me ask you a question.
Then what?
Let me ask you a question.
Okay.
Is the company that's currently the servicer, are they the original creditor?
They are not.
Oh,
No,
okay.
sir.
So let me ask you a question. How in the
I
hell,
was just simply informed of
how
them.
would they get an original? It's the same thing with
I don't
it's
know.
the same thing with a regular debt collector. If you ask a debt collector, hey, you know what? I'm willing to pay you. Can you provide certification that you are the original account holder, and can you provide a copy of the original application with my signature on it?
Lee, I was going to ask you about this. If the creditor is not their original right, you really don't have a contract with them. That's basically what you're saying.
Not only that, it is federal fraud. It's gone out of the state venue right now because you're talking about a financial transaction. This is now the FDIC. This is all sorts of different things in the federal realm. So the bank has to maintain their records for a minimum of 7 years, right?
Okay.
So if within that period of time, by some magic, the bank still has the original, they're doing some other shit with it. And I know for sure, I have proof that the bank is doing some other shit with all the original stuff. And it's no longer original. I know that for sure. So that's why I'm telling you that.
And now I'm outside of my 7-year mark as well.
That's
So-
fine. But again, remember, the bank has to keep the original for 7 years. Who you're dealing with is not your original bank.
And it's over the 7-year mark, so nobody's really got the original but me without what signatures.
Exactly. And kicker, all right, let's go down the devil's advocate route. Let's say both of those banks are working together and they go, hey, you know what? I still got the original. Here you go. And they bring it to court. And you're like, shit, fuck, what the hell? Right?
Lee, that's the first you've cut. Go for it, buddy.
Right. So here's the kicker. They still can't win. Why? The original has to be unmodified.
And the modification was when they transferred my mortgage to a different company without my consent.
Exactly. And in order to do a transfer, you have to have some kind of modification of the original instrument, which includes the stamp from a bank, which they all do. They're going to stamp it to say pay to the order off, or some other verbiage on there which basically shows that they've been paid since they got the note.
Fair enough.
So
And then, so say they do get it and they come to court with it, even though it's been modified. But I asked for that accounting.
no. Let's not skate past that.
Okay.
If
So that's,
if it's
so what happens if it's all null and void? What's the outcome for me then?
no.
Do I just stop making my mortgage payment?
Hold on. Let's slow down a bit.
Okay.
Let's take this in for a second. If they bring an original to court with a stamp on it, it is no longer an original.
Since they chose to sell it to somebody else.
You don't care what happened to it because they'll try to explain their way out. The original does not have a stamp on it. That's the point.
How does it not have the stamp?
When you signed your mortgage documents, did anyone stamp those documents?
There are parts of it that I believe
No,
are
no.
stamped.
When you signed your documents at closing for your house, was someone there with a stamper that stamped the front and the back of your note that says pay to the order off?
No, it was just me and
Good.
the agent lady.
You're done. That's it. That is no longer an original document. It's modified. That alone gets your case
Interesting.
dismissed. Don't argue the rest of it. Move for dismissal.
Okay, so say I do all of that and I go through dismissal, then what happens?
Then the bank has to release all claims against your property. You're home free.
And then it's mine, free and clear?
Yes.
So why would the same not have applied to the guy who started Property Defense Network? Is his name Zach, I think?
Yeah.
So why did the same not apply to Zach today with his Porsche?
Because Zach is going a completely different route. He's going a constitutional, free man on the land route without using law.
Ah.
And the state court is never going to recognize the Constitution like that. You're going
I'm sorry, but the state court sucks.
Just a quick question, Lee. So I understand the difference between what you explained right now versus what Zach is doing.
Mhm.
much better to argue a contract, right? Like, does this apply, let's say, with credit card debt?
Yes.
Could you give me a quick example of how this would apply to credit card debt?
Yeah, you could write to the credit card company and say, hey, you know what? I want to make sure that I have proper records. Can you confirm that you have a copy of the original application? You send them that letter. They might come back and say yes. They might say, nope, we disposed of it. Right?
Yep.
And again, you have to think like a child here. You cannot create a letter with 15 or 20 different questions and bombard them with all kinds of stuff, because it will not work. You know, you'll see all these 15-page documents online on how to do this and that and discharge debt and whatever. They don't work.
And question for you, Ryan, I guess, with the credit card debt question.
Yep.
Has your credit card debt are you getting contacts from any third-party entity about your debt?
No, not yet. I've been making payments, but I'm thinking of stopping because I can't stand these banks. They're a bunch of crooks.
Okay.
Gotcha.
But I was just curious about, right, when you have credit cards with creditors, you know, I'm well aware that they're not creditors. We're the creditors, right? And so,
Right.
What's the right way to
Wait, well, to answer the question, you have to say, what are you looking to accomplish?
I mean, I have no problem continuing to pay my debt, but I would rather not pay my debt and figure out a way to get out of it. But all of these things, like, I'm very interested in law in general, but these discussions and kind of what's going on in the country, obviously with banking and the federal government, you know, there's a lot of stuff they're doing that's not cool, right? So when Nixon took us off the gold standard, all those different things, right? The U.S. dollar really is backed by nothing, and so
Right.
I was very interested in Zach's argument, which is, you know, you don't have a valid contract if you haven't provided consideration. So I'm looking at that argument across all debt positions, across all asset classes. I just am curious about some of these arguments and actually how they play out, right? Like, let's say hypothetically, I'll just give a hypothetical situation. Let's say that I had a $10,000 credit card debt, and let's say that I lost my job, and let's say that I was about to stop paying payments on that credit card, and they were going to start charging me late fees, start calling me up, harassing me, et cetera, et cetera. What's the right way to play a situation like that, where you could potentially get your debt thrown out based on them not having a contract, maybe it not being an original, et cetera, et cetera? Does it make sense?
Somewhat. So again, we have to look at the end part of what we're trying to do. So if you're saying whatever, it doesn't matter what the situation is, you simply don't want to be accountable for the so-called debt that a credit card company might come after you for. Okay, so one of the first things I would do is, so a credit card is a little bit different if you're not in default yet, or if you're not, you know, in delinquency status yet. I would create a letter of revocation of power of attorney and authority, and you basically state that any authority or assumed authority the credit card company has based on any contract that you've signed, you're hereby withdrawing such authority. You sign it, notarize it, keep a copy, and mail it off to them. Once you do that, that creates an interesting scenario. I've done it.
So a revocation of power of attorney, that's basically withdrawing consent that they have power over any contract that you guys have signed together, correct?
Well, power over the account that was created from the contract.
Gotcha.
Right. So that would mean that even though they may restrict the account, right, they cannot theoretically close it traditionally. So what they'll do is they'll keep telling you, oh, you're delinquent, oh, you're delinquent, oh, you're reporting late on the credit reporting agencies. And again, you can get creative with that, but your ultimate goal is to stop them from being able to like bring you to court, right? And that's one way to stop them from bringing you to court. The mortgage is a little bit different because there's a whole lot of clauses and all kinds of different BS in there that will stop you from doing just that, right? And because it's also filed in the county and the deed and stuff that's involved, that stops you from doing that with a mortgage. But with a credit card, you can again send them that notice, revocation of power of attorney and authority. That's important. And authority, because they'll claim they don't have power of attorney. They'll try to use plain language in one sense, but then they'll try to use it later on in legalese. So if you say revocation of power of attorney and authority, that covers both spectrums, private and public. So whatever they think they're doing, they'll no longer be able to do it lawfully. They can still do stuff privately, like
Gotcha. Revocation of power of attorney and authority has to be done at once.
right, it's the title of the document.
Yep.
Yep. Once you do that, I would suggest you max out the card or do all that you can. And once you stop paying, then you start your inquiry. You say, hey, can you provide me a copy of my original application? Right? If they respond and they say, well, you know, we don't have that readily available, whatever. If they give you any excuse other than what you asked for, that's what you want. That's your ammunition. Right?
Totally. You want to make sure that you use trackable documentation, right?
Right.
Where you're sending letters that require signing, right? Things like that.
It doesn't matter. Just certify. You just want to know they got it. It doesn't matter who signs for it.
Gotcha.
Yeah, so certified mail is fine as long as you can track that it got to the address and it was delivered. Once it's delivered, it's considered accepted unless they send it back to you, which they won't, because their mailroom, first thing the mailroom does when they get stuff is, that's why they send it to a P.O. box. They get all these letters, they just strip them, just take off the envelopes, to throw them in the garbage, and then scan all the letters and send them, you know, to a department to sort them out. So they literally can't refuse the mail, and they don't want to either. So that's what you ask for first. Then secondly, you ask for full accounting for the accounts to make sure that your payments were applied properly. These are credit card and banking terms, right? You're saying you want to make sure your payments were applied properly. So in order to do that, you need to review your account. So you need full accounting. And they will not send you that. They'll send you some bullshit like statements, you know, some kind of alternative ledger, all sorts of different nonsense that you didn't ask for. And that's fine. Just keep a copy of it. And then in the final part of it, you can say, hey, I realize that you've restricted my account, so I respectfully ask that you return my application and all my rights, titles, interests, and property. And that will throw them in a loop.
Now, when you ask for your rights, titles, everything that you just said, are you essentially, what are you essentially asking for if you're in a position where you already have debt on the card?
No, okay.
And then,
good question. Your idea of debt is not debt. Remember, it doesn't matter what account you have. the banks do not lend or deal in money anymore. All you have
That's
is a
right.
debit side and a credit side.
Yep.
There's no cash, there's no money. Debits and credits, debits and credits. And oftentimes you don't even see the dollar sign. It just shows you an amount. So that's where your focus should be. Stop thinking that you just spent money. Just because the banks gave you some number and the number keeps going up and down based on your spending habits or what's transferred in there, that's not money. It's just digits.
Yeah, totally.
I can create an app and I can make the app do the same thing. That doesn't mean it's money. So, if you take your idea of debt out of the picture and you go, well, because remember, in order for you to get the credit card, you had to sign an application. And you had to send it to the bank. And then the bank opened an account, whether it be a bank account, a credit card, debit card, whatever. They created an account based on that information you submitted. They didn't have the account before you submitted the application.
Right.
So, that's why they say it's your account. The problem is, they didn't tell you that you can restrict that account. You can tell them what to do, but they won't do it because you're considered a minor. I know that sounds strange and crazy, but
This has to do with your Social Security and your birth and how that is related to the corporation of the United States run out of British Columbia, correct?
not
like,
necessarily, because what's happening is when we're born or when we come to this country, if you're not born here, and you start school and you do all these things, there's already a record once you start school. Your name they put your name into different things, change it up, create other names and all this other stuff. You're considered a minor because that's where you start out at if you were not 18 when you got here. And of course, you can't be born 18, right? It's impossible. So everything that you're doing is based on the fact that you're classified as a minor from the get-go. But at no point in your life did you declare that you're no longer a minor.
Oh, that's fascinating. Interesting.
Right. So the public record shows that you're still a minor. So you're treated as a
That's
minor.
not. So you're saying So you're saying, okay, let's say I was born here in the United States, right? You start off as a minor, you go through your processes of life. So you're saying that when you turn 18, that's not an intrinsic value of yourself turning 18 is like moving from minor to
No.
adult.
There used to be,
Interesting.
remember in ancient times, you probably heard of this, there used to be something called a rites of passage.
Right.
That doesn't exist anymore because you're dealing with corporations.
Interesting.
In order for anything to happen, it literally has to go on paper.
So any person that hasn't had a documented rite of passage is still a minor in the eyes of the U.S. government?
Absolutely.
And belligerent.
What was that, Luke?
They view you as belligerent,
Right.
not being able to handle your own affairs. That's legally, financially, all of it.
So let me ask you, has anybody in this chat right now established that they're 18 plus
I have.
legally?
I have.
You have?
Yeah.
And has it worked for you? Like everything went through exactly as it should have been?
When you say everything went through, what does that mean?
Like establishing that you are not incompetent, that you're not a minor.
But I think the right question, so getting back to the credit card example, so obviously if they're looking at you as a minor, what is exactly happening, and why is that important? And then obviously we can ask the question of what does it mean to be, I'd use the word emancipated as a minor in the eyes of the government. I think that's kind of the right way to look at this, or at least try to figure out what it means.
It's a very big question, but I'll try to simplify it. So, the idea of a minor, again, has to do with what's on paper, because all these corporations come into play. Back in the day, we all, when I say we all, if you believe in reincarnation, everyone that's here on the planet right now, or on the earth, were here before, right? And this is why you have pockets of people who are, it just appears that there's a small group of people that's always challenging the government. There's never 100% complicit behavior. Anyways, we all used to be knowledgeable about the law. When I say we all, I mean everyone. Everyone in society had a law dictionary in their home, which was the Bouvier's Law Dictionary. Everyone knew how to state a claim in a court. Everyone knew how to handle their own affairs. Everyone knew how to handle business and pass that knowledge on to at least two members of a family. That changed when we started having wars. When you have wars, what do you have? Destruction and loss of knowledge. Right? So,
Yeah.
and also the destruction of societies. So communities and, different people coming together to make things work and make things happen and challenge the government to do better. Right? That was, of course, not very favorable to the people in political power. So that's why they go to war every single, there's no 10-year period that we're at peace. Since World War I, there's always something internationally going on to cause an emergency of some sort, or some health emergency, some kind of emergency to cause the United States to go into a panic. And you can look at this in our recent history and even our longer history. But anyways, because we've lost that knowledge of how to handle our own affairs, that included the fact that corporations were very young back in the 1800s, right? If you notice, if you ever look at any court case or look at the history of court cases, you won't find many cases beyond 1850. Everything, or I'd say 1800. Most things are way beyond that, and that's what they try to focus on, because the cases before that, people were actually winning almost all the time. And if you have cases where people are mostly losing now, it's very hard to find winning cases and be able to use them. And now they charge you a fee to see the case details. Like, you can find a case, but you won't find what the parties filed into the case without paying a huge fee. And that's purposeful. That means that most of the knowledge you won't be able to get and figure out, okay, how did this person get to this result? You have to literally reverse engineer what the judge said in order to figure out a lot of this stuff. So when it comes down to the whole minor thing and why we have this nonsense of paperwork, it's because the introduction of the Federal Reserve and all these corporations, and the laws now in favor of the corporations more than they're in favor of the people. So you now have to find way more creative ways to get a remedy than simply stating a valid claim in court. Now you have to follow rules. Now you have to come up with all kind of evidence. You have to come up with basically everything. And
Yeah, it makes
on top of that, we are in a perpetual state of fight or flight mode. Most of us don't have $10,000 saved up so we can quit our job, take a break, and then decide if we want to go to work again. We literally have to keep working or we're fucked royally. So Um, that's the history in a nutshell. But it really started getting bad when the corporations figured out that they didn't have to tie everything to gold, and they could start basically fudging the numbers. Right? So the stock market crashed because the values didn't make sense anymore. The people were too knowledgeable at the time, right? They knew that gold and silver were the only precious metals worth anything. And why is gold valuable anyways? It's because of what it can do. And you can dig into that in any way you want to. Gold is in every piece of electronic. Silver is in every piece of electronic.
Yeah, I used to be a commodity broker.
So you know exactly what I'm talking about.
Yeah, I follow a lot of what's happening in the bond market and spot metals and paper metal as well. With respect to the miner, like everything you're saying makes a lot of sense. So when you do the form, you revoke the revocation of power of attorney, revocation of authority. You send those in, and then obviously you ask for your accounting. You ask, to see an original document, and then you brought up the miner. How does that play in with that scenario, and why is that important, and where were you going with that?
Okay, so the miner. So like I said, when we were born, all the way up to 18, to 17, we're considered a minor. If you're considered a minor, one of the things that come into play with law is that a minor, if you contract with a minor, the minor has power over you. Now, what does that mean in contract law? That means that if you contract with a minor, the minor can revoke consent at any time. You can withdraw consent. You can cancel a contract. You can, that's why they always say you can't get a credit card till you're 18. You can't do certain things until you're 18. Because physically speaking, has nothing to do with what's on paper, right? It's how long this legal entity has been so-called alive on paper. So you being a minor, you can cancel all contracts on that basis, literally. But you have to establish that and prove it. You can't just say, well, I'm a minor, because the first thing they're going to say is, well, how old are you?
That's literally the next question. Yeah, how do you prove that you're a minor and that that situation of what you talked about actually exists? I'm sure there's probably a law or something that states that, right?
Yeah, absolutely. It's in the law, and it's in the law dictionaries. So one of the kicker things here is this is where we start going into the whole legal fiction and the social security account and all that stuff. Okay. If someone says, okay, what's your name? You never answer to that. Ever. Your name is not what's your name? What is not your name? It's word semantics, it's spell casting, it's necromancy, it's all sorts of witchcraft when law enforcement or the government is talking to you. And if you're not aware of it, you fall for it. What's happening is, if someone says, who are you? What is your name? That is irrelevant to any situation, because especially in court, if someone is asking who you are, then how are you bringing a claim against me if you don't know who I am? So that means that they're talking about something else. You can't try to identify someone after the fact of anything. It has to be before. But what they're trying to get you to do is to admit that you are your person, or you are your ID. You are the name on the paper, which is a violation of natural law and a violation of constitutional law and a violation of the laws of the universe. You cannot exist in two places at the same time. So if someone says, is this you on this ID? No, it's not. It's a picture. It's a representation of an image. I know it sounds crazy. I know it sounds weird, but it is what it is. They will not ever tell you this stuff.
Yeah, no, I mean, it makes sense. I mean, this is why people don't talk. This is why smart people don't talk to police officers, right?
Right.
Because, police officers, their only job is to entrap you, and they do that by getting you to admit guilt, right? And in whatever form or fashion they're coming against you. But yeah, what you're saying makes a lot of sense, right? So
the whole minor thing, again, you are not the minor, right? They're talking about the person on paper. You're walking around with this name, you're using the name, you're doing all these different things, but you don't know what you're doing. So that's why you're considered a minor. That's basically what it boils down to. You think you know what you're doing because you're following everyone else doing the same thing, but that does not mean that's what you should be doing. If you're competent enough, then you'll know how to handle these names and these questions and these different things that happen.
totally right. So then the name on paper, your legal born name, that is the minor, but you as a person in the world is separate from that.
Exactly.
Right? All your God-given liberties, protections, unalienable rights is different from that minor that's on paper. Okay, so how do you use that against? How does that play out though when in this particular situation?
I wouldn't go that route in this situation, because you have to know it long enough and be able to articulate it to use it.
Right.
If you go down this route of trying to say, well, I'm a minor, not only have you bound yourself to the paper version, you're now responsible for any consequences that come with it.
Right.
So I would not suggest anyone say, hey, I'm a minor and I made this contract when I was a minor and I have not declared myself to be a person of majority, because you fall into all sorts of trips and traps that may not be beneficial to you, because you have to know all of the terminology that's going to be used. Even if you declare from the start of the case that you're only proceeding in plain language and in the English language only, they can still trip you up. So I wouldn't go that route. So but in larger situations, right? If you're dealing with law enforcement or different things like that, making the declaration that you are no longer a minor and you're of the age of 18, you're competent to handle your own affairs. When you are dealing with, let's say, the credit card situation, right? And you're doing certain things. So if you're keeping the account open and you want to assert certain rights, again, you have to know what you're doing. You can't just send them paperwork and expect them to comply. They're assholes. Like, I kid you not. They're trying to steal from you, so they'll try everything possible to continue stealing. That's just the nature of things. So if you want to keep the account open and you want to go down that route instead of just getting rid of it, getting it off your credit and starting all over again, then what you would do in that situation is you would declare your minor account, you would declare that you're no longer a minor. You would declare complete control over the account that was created based on your signature, and you would send them a letter of instruction to say, hey, this is what you're allowed to do, right? And you come up with the terms and the conditions of what they can and what they cannot do. Is that making sense?
Yeah, sure. So obviously, one route is basically you're saying you do the revocation of power of attorney, revocation of authority. You would claim yourself as not a minor, and that you have full power over the accounts, and you would submit terms if you wanted to keep that account open. Otherwise, what's the other way?
The other way is still to submit the power of attorney. The revocation of power of attorney and authority. You're still doing that, but um, because that stops them from fully closing the account, right? That stops them from selling the account to a debt collector. So that gives you the power to still ask him for full accounting, a copy of the contract or the agreement, you know, and, you know, do other different things within that realm while not paying. So then you can say, hey, you know, if you decide to continue restricting the account, you can now claim all your property back. When I say rights, titles, and interests, what I mean is they're investing in these accounts. They're selling them. They're selling the information. They're making money off. So basically, they can't make direct money from the account itself, but they can take the interest that's made from investing these accounts. So what you're doing is you're saying, hey, being that you're dishonoring my agreement that I sent into you in the form of an application, give me all my shit back.
And okay, and so by give you all your shit back, what would be like an itemized?
No, you're not going to itemize. So one of that would be when you say, so you're saying all, right? So in whatever form it is, however much or however little it is, you're just asking for that back. Because again, if you limit yourself to say, hey, all right, the banking manual says all deposits are property of the depositor. So if you say I want all my deposits back, what about all the withdrawals? What about all of the investments that happened? What about any other monies that were made? What about all of those different things that you may not know the terminology for?
Right, you would sell yourself short if you tried to itemize it in what you think instead of just asking for it in its entirety.
Right. So you just tell them, return it to this address. And they, however way they want to do it, you know, in the form of a check, whatever, reopening the account and giving you all the credits that were due, however way they want to do that, that's what you're asking for.
Now, obviously, any person who's new to something like this, in their mind, they would say, okay, well, if the credit card has debt and quote unquote, I owe them money, which we've already established that it's debits and credits and that there is no money. Mm-hmm. In your mind, when you go through a revocation of power of attorney and authority, and then you say, hey, I'd like all my interest, titles, and
property back,
rights back.
Mm-hmm.
Yeah, interest. I want all my interest, titles, and property back. In your mind, you think, but there's debt here, and so what do you, in a real world situation, what do you actually expect to get back? When you,
right. I know it sounds crazy to a normal mind, right? Like, I owe this money, you're asking them for money back? What kind of nutcase are you? So again, you're only seeing one side of the accounting. That's one. So if they're ever that crazy to give you the full accounting, which again, I've never seen a case of it. The only time I've ever seen a court case allowing for what do they call nunc-pro-tunc accounting was from a credit reporting agency, where someone was trying to verify something, but the credit card company only showed certain, like, up to a certain amount of time on your credit report, and they needed to go back further. So the credit card, the credit reporting agency refused to provide the information, and that's how I knew the credit reporting agencies were actually government agencies. They cannot refuse the FOIA request. So the court actually forced the credit reporting agency to provide every single thing in that person's record. So I doubt you're going to get full accounting. So that's how you're going to get them to comply, because if they're not going to provide it, then they're going to say, you know what, let's work out a deal. the first thing they're going to try. Because if
Okay, and so if somebody makes it this far, what type of deal will these people try to offer you, and what is your minimum standard? Or
I don't know. All of them are different. They're not going to offer you the same thing. They might say, you know what, you're crazy, but that's fine. You just want it on paper. Because ultimately, let's say they refuse or they deny everything you ask for. That's fine. That's okay. Sue them in court. File a claim. State that and this would be a federal court because it falls under the Fair Credit Reporting Act, right? And also it's a financial matter that you would believe is beyond $15,000. Now, if you sue them in court, they have no choice. They have to provide that under discovery. If they don't provide it, they're in contempt of court, and you can ask for whatever damages you're claiming. And the damages would be, you want everything back from the account because they are violating the agreement. You agreed to have an account open and give you a certain amount of credit every month, and now they've violated that. So that's a breach of contract. Does that make sense?
Yeah, totally.
So once you sue them, again, I don't know what they would offer to negotiate. It depends on your confidence level, number one, and number two, what you're willing to accept. You can give them a demand and say, hey, you know what? I'm willing to let go of this account if you give me $50,000. And they're going to, decide to accept it or counter or tell you you're crazy. It doesn't matter. Because at the end of the day, if you know for sure that they're hiding something, which they'll show that when you ask questions, you'll know if they're hiding something or if they're trying to be forthcoming.
Fascinating.
Yep. But I do have to run, guys. Have to take my little one to dinner.
Appreciate your time, Lee. You're the best man. I'll see you back in the room, and I'd love to pick your brain some more.
Sure, no problem. Well, y'all have a great evening, and
You are amazing. Thank you for everything.
yep, you're most welcome. Talk to y'all later.
Enjoy your week.
Thank you.
Yeah, we'll talk.
Bye, everybody.
Bye.
Take care.